whenever we are saying that I'm exercising my freedom of speech and expression, the Constitution lets you exercise it, please subject to contempt of court.
This law actually originated from the 14th century.
So basically, the debate is between to what extent can one exercise their freedom of speech,
Yeah.
and to what extent can someone be held guilty for contempt. So
Hello, everybody. Welcome back to We Talk a Lot, or in Bhumesh's words, We Talk a Lot. Yeah, sorry, Bhumesh, I had to do that. But yes, welcome back. We have successfully managed to be able to shoot another episode, and I think that's a big thing. And thank you so much for all the love and the great feedback we've received for the previous video. That's actually kind of pushed us to do this today. So the topic for today is freedom of speech vis-a-vis contempt of courts. And Bhumesh, what do you have to say about it?
So I feel this topic has become extremely relevant now in light of the Prashant Bhushan's judgment. Like
Yeah.
I've been seeing a lot of lawyers, lot of judges writing about this, having different opinions here and there uh, on a lot of forums, and it's actually quite interesting to see all their views. So basically, for people who are not aware of what the Prashant Bhushan case is, as you might know by the topic itself, it's something got to do with contempt of courts. And the case started with two tweets. He tweeted about the judiciary and the current chief justice. What he said was, when historians in future look back at the last 6 years to see how democracy has been destroyed in India, even without a formal emergency, they will particularly mark the role of the Supreme Court in this destruction, and more particularly the role of the last four chief justices of India. So this was the first tweet, which he
Yeah.
tweeted on the 27th of June. And the second tweet was that the Chief Justice of India rides a 50 lakh motorcycle belonging to a BJP leader at Raj Bhavan without a mask or helmet at a time when he keeps the Supreme Court in lockdown mode, denying citizens their fundamental right and access to justice. So, because of this, the Supreme
Yeah.
Court took suo motu cognizance. Suo motu cognizance is basically the Supreme Court took authority of the matter and took charge of the matter rather, and took it up for hearing on contempt, and they convicted him. He's guilty of contempt of courts, pending sentencing, which will be announced soon. So yeah,
Yeah.
this is basically the background of the case.
So when you basically insult or lower the esteem of the judiciary of the courts of our country, that's when you like are guilty of contempt. But what I feel is that there is also a very important aspect, which is why it's gained so much relevance, and that is freedom of speech. And that's exactly why
Of
we
course,
kind of
of course.
worded our the title for the episode is freedom of speech vis-a-vis contempt. So essentially, what it is that when all the citizens of our country have the right to speak and express as they please, then can that right be curbed? Or can someone say that, listen, don't insult the judiciary or don't express your opinion, which is derogatory towards the judiciary in exercise of fundamental rights, because this amounts to contempt.
So basically, the debate is between to what extent can one exercise their freedom of speech,
Yeah.
and to what extent can someone be held guilty for contempt. So basically, where do you draw the line? And secondly, how important is it to preserve the sanctity of our judicial system? As we said in our introduction, that it's just not going to be the both of us yapping. We'll
Yeah.
be calling our friends, colleagues, and other dignitaries. Tonight, we have with us our friend and colleague, not
Yeah.
so much as a dignitary, but his insights on this subject are quite valuable. So I invite Mr. Karma Vivan.
Woo! Yeah, we have a first guest. Someone actually wanted to join us. Yeah,
Hi
Karma's
guys,
here.
how's it going?
Hi,
Hello,
hi,
hello,
hi, hi.
hello,
What's
hello,
up?
I
hello.
feel I realize finally all our numerous random discussions are gonna come to some use.
Yeah.
I'm super excited to be with you guys. Hopefully by the end of this, at least somebody will view me as a dignitary. I don't know if I still have friends, but yeah.
Yeah,
Well,
no,
you'll have
no.
a
You'll have
colleague.
both
So
of us.
lesser known facts is that Karma and I both belong to the same chamber,
Yeah.
and that's how we've known each other since 5 years, and we've had numerous discussions and numerous debates on various legal topics, but never put it up online. So let's see how
Yeah.
that goes now.
I'm an outsider, I think. I hope you don't rag me or something over
No, but it's fine. You're not an outsider because for some reason we've all color coordinated to blue.
Perfectly, yeah.
I kid you not, we haven't pre-planned our outfits. We all have just coincidentally worn the same color. I have no idea how. And I find it crazy cool that this is happening. I
You
think this
find,
episode is meant to be.
you know that Pi comes from a civil original side chamber when his top button is buttoned up like this, fully done.
And we come from a criminal side chamber
Yeah,
when our two buttons are open.
बस हो गया अभी अपना कंटेम्प्ट नहीं होना चाहिए रुको अभी
So let's move on to the topic. Let's
yeah.
discuss what freedom of speech is and what are the exceptions to that.
I think the whole debate right now has started because of this freedom of speech topic, and I think that's something that will interest our viewers. So, Karma, what do you think? Firstly, let's begin with you because you're the guest.
I think that freedom of speech is one of the most basic guaranteed rights to all of us.
Yeah.
I mean, in all countries, in all democratic countries, it's one of the first few rights that come up, freedom of speech and expression. So whenever we talk about anything that's trying to restrict or limit the freedom of speech, we have to be very careful and we have to be very circumspect in defining exactly what is required to restrict that freedom of speech. So I think more so than the freedom of speech, we really have to focus on the law that approaches the restriction and define it and codify it in such a way that there can be no gray area,
Yeah.
no gray area.
Every person, every citizen of our country has a right to freely speak and express the way they want to. Every fundamental right is subject to a certain reasonable restriction. There are certain restrictions in 19.2. So I'll go to that directly. So under this 19.1a, which is the freedom of speech and expression, it is subject, it's not absolute. It is qualified by certain exceptions. And I'll read two. So nothing in subclause A of clause 1, that is the freedom of speech and expression, shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of, now this is the interesting part, the sovereignty and integrity of India, let's leave it aside. The security of the state, let's leave it aside. Friendly relations with foreign states, let's leave it aside. Public order, again. Decency or morality, okay, and this is the main part, or in relation to contempt of court, defamation, or incitement to an offense. So I don't know how many people know it, and I was pretty intrigued to find this out that our freedom of speech and expression is subject to contempt of court.
Correct. We should probably now digress to contempt of court because now that it is a restriction to the reasonable, it's a reasonable restriction to the fundamental rights.
Yeah. So, like talking about contempt of court, the funny part is that the contempt of court or the phrase contempt of court is not defined anywhere in this whole constitution. But under Article 129 for the Supreme Court and under Article 215 for the High Courts, both of these courts have the power to punish someone for its own
I
contempt.
was just going to tell you guys a little bit about the history of the contempt of court. So
Yeah.
this entire idea of contempt of court came from the idea that law used to be the king's word and the king's word was basically God's word. So it was actually contempt against the king and contempt against God. So from there was this idea that whatever law that was said by a judge was actually divine, and anything that was any willful disobedience or any willful disobedience was considered to be contempt. So this law actually originated from the 14th century. So it goes back like a long time. And one of the first cases, actually damn interestingly, is this case of Henry IV and his son Prince Hal. So Prince Hal was Henry IV's son. One of his servants was actually accused of a felony and was made to appear before the king's bench.
Yeah.
When he had gone to the king's bench, Prince Hal appeared and demanded his immediate release. The CJ at the time, Gascon, directly but firmly told the young prince that, look, this is not happening. I have been given the authority by your father. And when the young prince refused, tried to take the servant away, then the CJ Gascon went and put him into jail. So this is the prince into jail. So at the time, it was a huge scandal because everybody thought that this is the last time CJ Gascon is going to be CJ. And after this, he may be the late CJ. But actually, the king was super impressed by his CJ because he managed to stand in the face of authority and still deliver justice. And so he actually awarded the CJ, and he was very happy with his son for finally listening to the CJ as well.
I just have one thing to say. Is this England or Delhi? Because ideally the prince is like, "Janta hai mera baap kaun hai," and he just went away with it.
Yeah, no, that's what I was going to say. Basically, contempt of courts came into existence because some whiny prince, some Joffrey existed in 14.
Yeah.
Some Joffrey basically caused contempt of court. There are two types of contempt basically. One is in the face of the court, and one is behind the court by some matter publication.
In fact, there's an interesting judgment by Lord Denning in R
Yeah.
versus Balogh.
Yeah.
And it's
That's the
famously called as a laughing gas case,
Yeah.
where basically what happened was, so this person, Mr. Balogh, decided that I'll get the laughing gas, which is nitrous oxide, whatever. Okay, my chemistry is not very good, but he
NO2, you're
basically
not wrong. Yeah.
okay.
Neither is your law, Bhumesh.
Edit.
No, you're not editing that. Just go ahead.
And so basically, he went and he robbed a cylinder of nitrous oxide.
Yeah.
And what he did was he tried a recce where just previous night of the hearing the next day, he goes to the rooftop and tries to figure out where the air ducts are, and he figures that out. But coincidentally, two of the guards saw him. So the next day when he enters the court, so those guards stop him and they open his briefcase and they find the cylinder. They immediately take him to the other court for hearing. So he admits that I have stolen this cylinder, but the judge convicts him for contempt of court and puts him in for 6 months. Now he kept on pleading as to why is this contempt? I did not do anything, nothing happened. I was just planning, but nothing turned out. So then he appealed that decision, and in that, Lord Denning was the sitting judge in the appeal, and where Lord Denning held that there is no contempt in this. He did rob the nitrous oxide, but there is no contempt in it because he tried to do an act, but that act never culminated into anything. So
Yeah.
that's what Karma was saying, that contempt in the face of the court. So
Yeah.
contempt in the face of the court is basically something happening in the court. Like, can we move ahead to our act, the Contempt of Courts Act 1971? And surprisingly, there have been two Contempt of Courts Acts before this, one in 1926 and one in the 50s, where they never defined what is contempt of court. In fact, it was only the Act of 1971 where they have defined the
term contempt.
The term contempt of court.
Yeah.
And people should know that there are two kinds of contempt. One is a civil contempt and one is a criminal contempt.
Civil contempt basically focuses on ensuring that any judgments or orders of the court are properly adhered to.
Yeah.
So the entire thrust is behind making sure that any judgment or order is actually followed out as the court wished it. And anybody who willfully disobeys such a judgment or order of the court will be held in civil contempt of court. For criminal contempt of court, you have essentially three types of criminal contempt. So one is scandalizing the court by lowering its authority. This can be done anywhere. This can be done while published. This is also what Prashant Bhushan has been held guilty for.
Correct.
Yeah.
The second is interference in the due course of a judicial proceeding. So this is during a judicial proceeding, if you actually interfere with the proceeding. And the third type of criminal contempt is obstruction in the administration of justice.
Like chappal.
Like chappal.
Yeah.
Yeah, it could mean anything actually, not chappal.
I mean, like, example, chappal is an example.
So
in chappal, you could be all three. You're scandalizing the court, you're interfering with the due course of a judicial proceeding, and obstruction in the administration of justice. So chappal is a lethal weapon.
Basically, that is both are to protect the whole judicial or the due process as a whole, both these contempts. But one is more objective, you can say, because you can come to know when someone has breached an order or not. So you can come to know, okay, the civil contempt, you can kind of make out with the facts. So it's more objective, according to me. While the other, which being criminal, is more subjective, because at the end of the day, it is for the judge to decide whether a certain act falls under being scandalous or obstructing the justice. And,
Correct. One may perceive something as scandalous, the other judge may not.
Yeah.
So That's extremely
That's
subjective,
what's
and
happening actually.
hence I feel like the act right now. Suppose they use the word scandalous, they use the
Yeah,
word lowering the authority, they use the
yeah,
word obstruction, they
yeah,
use the word interfering, but none of these words are defined in the
yeah,
act. So
yeah.
basically, it is upon a judge to just decide by himself or herself that what these words actually mean and what is the extent of these words.
And because that ambiguity or that vagueness still exists, then making it subject to a freedom of speech and expression makes it a little doubtful in the minds of citizens. Ki, okay, so maybe if I say something, I might not be held guilty of contempt, but if Karma
Correct.
says something, he could be held guilty. It all depends on the situation. I think that's where this whole debate is getting like kind of like it's getting spun out.
This creates a scenario where, there's too much vagueness or too much subjectivity and it's not clear cut.
In fact, I want to go back to our definition of contempt, which we pointed out, and the second one was obstructing the course of justice.
Yeah,
Okay, so what I want to add here is the news channels nowadays. I
yeah,
mean, they have the running commentary on cases, uh, which they have the complete right to. Of course, everybody in we are in a democracy, and everybody has the right to know what happens in our courts.
But
But the
Bhumesh,
way they put it,
the nation wants to know. The nation wants to know, Bhumesh.
yeah.
so basically, that's what I'm trying to talk about. But interestingly,
I'm sorry.
that part of interfering with due course of any judicial proceeding.
Yeah,
Now, the
yeah,
Contempt of Courts Act in Section 3 have also defined what a judicial proceeding is. So, a
yeah,
judicial proceeding in a civil case is when a plaint is filed, but a judicial proceeding in a criminal case is when the charge sheet is filed. So there are a lot of things happening before the charge sheet because an FIR is registered, arrests can be made. So the media can say, or not just the media, any person can say whatever they want before the charge sheet, and that will also prejudice the rights of an accused. But that's a topic for a separate discussion. But that's what I'm trying to say. The media has so much power, and they do not come under the ambit of this section or this act. But this is just my frustration towards the media. I've been speaking that about in all our episodes. Even the previous episode, I've spoken about the media. So I should probably not speak much.
so, guys, episode 4 is gonna be about
Not the media.
contempt of court versus media versus Bhumish Bellam. And please do join us. Forget the media, okay? When a particular person is talking about the judiciary, he's exercising his freedom of speech, which is also obviously subject to contempt of court. But something which he's saying is not defined as contempt, like, so you don't know what you're saying, whether it's contempt or not. So
No, but
leaving that, so where do we draw the line? How do we know something that's contempt or
I'll tell
not?
you. I'll tell you where, because they
Yeah,
also use the word prejudice ongoing judicial proceeding. So,
yeah,
and judges are of course humans, and there are multiple judgments which also
yeah,
say
yeah,
that judges are
yeah,
humans and they
yeah.
can
We
be.
don't need
You
judgments
don't
for
need a
that. We know
judgment to
that.
say
Yeah,
that.
we don't need that judgment.
No, I mean like they can be influenced by the media. But
Overall, the whole problem is arising due to the vagueness in the definition of criminal contempt. Be that as in me, okay? Be that as me, and this is a question I'm putting to you all, and I'll answer it. What I want to know is, do you all think contempt laws should exist? And by contempt, I mean criminal contempt. Civil contempt, let's leave aside. Do you all think criminal contempt should exist?
okay, I would like to answer that.
Yeah,
I highly think yes, and
yeah,
in both ways, which is contempt in the face of the court
yeah,
and also scandalous remarks. The reason being, we are one of the largest democracies. Not
yeah,
one, we are the
yeah,
largest democracy in the world. And more than that, our population, like Indians, are known to have a lot of faith in
yeah,
things, and when someone has faith in a particular thing, it is very easy to tarnish their faith.
yeah,
More so in India, as we are all aware that the literacy rate is not more than 50%.
yeah,
So a lot of people's ideas, a lot of people's opinions can be easily influenced, and
yeah,
that could probably be contrary to the whole object of the judiciary because it's a third pillar of our democracy. And I
yeah.
feel that people must know how to respect the judiciary, because if the judiciary is not respected, the orders passed by the judiciary won't be respected. People won't put judiciary in such a high light where if something wrong happens, people won't be like, oh, the courts will handle it, the courts will do justice. So I think
Yeah.
that will reduce to a considerable amount.
So here I completely disagree with my learned friend Bhumesh. I think it's not a question of the size or literacy of a country, but it really has to do with how we want to be perceived as a liberal democracy. So when you look at several countries around the world, you see that the more liberal and more democratic countries generally are trending towards watering down this concept of criminal contempt, and especially this concept of scandalizing the court by through publishing material. So when you look at Europe, when you look at Germany, Europe, which are large, Germany, Italy, France, which are largely looked at as liberal democracies, they have the most watered down criminal contempt laws, where obviously if you have contempt in the face of the court, they can issue injunctions and they can take summary action, but there is no concept of scandalizing the court. And in these countries, people routinely and the press routinely criticize judgments and judges, and it doesn't seem to have led to any reduction in the sanctity or the authority of the courts in these countries.
But
If you look at US and Canada, unless there is a real and substantial danger to the administration of justice, which is that second point, during the court proceedings, there will be no contempt. There is no concept of criminal or contempt of law which scandalizes the court. In fact, the US Supreme Court in its entire history has only had one criminal contempt case, which was way back in 1906, and it's called United States versus Shipp. And the United States Supreme Court is held to be in one of the most powerful Supreme Courts in terms of the amount of power that it has been given under the US Constitution vis-a-vis the legislature and the executive. And even the mother of our country, the mother of the laws of our country, which have come from England, they have the Contempt of Courts Act. But in relation to contempt of court that scandalizes the court, the last conviction was in 1930. And in 2012, this has also been abolished because it was found to be too vague and not compatible with the freedom of speech. So if our direction as a country has to be towards moving towards a more freer or more liberal society, then we have to really examine what this does and whether the advantages, which Bhomesh has pointed out, I don't disagree with the advantages, but whether they really, how they weigh in terms of the disadvantages of curtailing free speech and the perception which the courts give themselves.
Yeah, no, but I think our statute is quite clear. Like if you read Section 5 of our Contempt of Courts Act, it is not contempt if you criticize a judicial proceeding or a judgment. Like if suppose in this episode we'll talk about Prashant Bhushan's case, so that can't be even whatever comment we give on the judgment, that cannot be construed as contempt of court. And also in the judgment of Perspective Publication versus State of Maharashtra, the court has also said that you have to use this power in extremely exceptional cases and very sparingly, and the object should be not to punish the contemner. The object should be to uphold the dignity of the court. So I think the threshold still remains the same even in India. Whether it's implemented, not implemented, and to what extent, that is another question. I think apart from that, the laws are already quite liberal in our country because they are in the act itself giving you, there are sections which say what does not amount to contempt.
Should I end the debate with my opinion? It's one all. One guy said it should. See, at the end of the day, I agree with more on Bhomesh's side. Sorry, Karma. To uphold the rule of law, to ensure that the law is followed, and to ensure that the three pillars of our democracy stand still and they aren't shaken, we need to have something to keep everyone's comments in checks and balance. Freedom of speech, at the end of the day, is a freedom which we all have. Today also you are exercising it. Maybe you are saying something contemptuous. Being Prashant Bhushan, who's been held to be guilty of contempt, it's not like he did not exercise his freedom of speech or he could not exercise his freedom of speech. He exercised it. Only thing we must remember, it has to be subject to something, because at the end we are a 1.2 billion people or whatever, how many people we are in the country. With such a large population, there's going to be diverse opinions. You're going to express it. At the end of the day, it's not like the freedom of speech does not exist, but we need to kind of uphold the judiciary and the judicial system on the basis of which our orders are passed and on the basis of which the judges give justice to the citizens. And I think to uphold that, we do require a contempt of courts.
Yeah. I think it's a great point to move to the Prashant Bhushan's case, because then there will be a premise to discuss this exact point which you raised.
Yeah.
So
Yeah.
as we read out the tweets, will this amount to scandalizing and lowering the authority of the court in any manner? Is the question right now. The Supreme Court has already taken its decision, held
See,
them guilty. So it's just
honestly,
Our
honestly,
opinions on the
our
matter.
opinions. We are covered under Section 5 of Contempt of Courts Act.
Yeah, our
so is
opinions.
Bhomesh's opinion,
Bonafide, our
which
bonafide
so
opinions.
so yeah, so is Bhomesh's opinion, which do not hold against him for the viewers. नहीं तो कोई phone करेगा भाई तू
And
बोला
in
था
public interest, in public
In
interest
public
in
and
public
bonafide.
interest.
Yeah.
So maybe in a way, Advocate Bhushan's or Mr. Bhushan's tweets were basically the frustration of an Indian citizen about the whole lockdown. Having said that, blaming the judiciary for the lockdown or for denial of fundamental rights of citizens, I think it's a little exaggerated because honestly, the judiciary is functioning. And we all have appeared before the courts at least once, and it's not like the courts aren't entertaining matters. They are entertaining matters.
And
So,
you don't know whether he was riding on a holiday, which the Supreme Court in the judgment said that it was the May vacation during that time he was
yeah. No,
riding
no,
the
I'm
bus.
not even going. I'm not even going whether the chief justice was right or wrong in doing what he did. Okay, let's not even get into that. According to me, I'm just saying essentially blaming the judiciary for the death of democracy and saying that citizens are being denied fundamental rights because of one chief justice riding a bike. I think that's really exaggerated. Maybe he wanted to be dramatic. Again, no offense to anybody. Maybe he wanted to be a little dramatic and kind of urge the people. But that is what kind of hurt the judiciary.
It may be wrong, but does that mean that it amounts to contempt of court?
So I think one of the reasons why this is so interesting is because Mr. Bhushan hasn't come around and said, hasn't apologized. He also, in his own mind, for his own reasons, feels he's doing what is morally correct by his own conscience.
Yeah.
So even when the Supreme Court asked him to apologize, he actually refused to do so because he
Today,
said that
right?
what
Yeah,
I will
today.
be doing is I will be violating my own conscience. And
Yeah.
I don't want to lie to the court and say I'm offering a bona fide apology because I believe in what I did.
Yeah.
Right.
So I think here it's a question more of two competing morals. I think what Mr. Bhushan is trying to do in his own way is trying to bring about change in the judiciary. And for whatever reasons, I don't think that he was lying or he was frustrated. He may have adopted the wrong means as the Supreme Court has held. But at the same time, I feel that there is a fundamental problem with the contempt law and the way it is being followed in our country. Because it's not as the saying goes on, which we hear every day, is that justice should not only be done, but should also be seen to be done. So I think it can be safely said this is a battle between few good men. I mean, both the judges of the Supreme Court and Prashant Bhushan, they're both trying to do the best for the institution. It's just that they're approaching it from two diametrically different approaches.
No, honestly, I don't think this will ever end. We all have our own opinions, but I think in a way, we all are kind of so. One thing we all are in consensus with is that if there is a contempt law, they must define what is scandalous, what is obstructing of justice.
Define each term.
So at least our rights are clearly defined. So a citizen is not confused about what
he can and what he can't do.
Exactly. So yeah, I think, and I'm in agreement with that. So yeah, if the contempt law should exist, I say yes, but subject to this qualification. And Bhomesh, you asked a question, I think, in the start, or you said you want to discuss it about the sanctity or drawing the line.
Yeah.
What was it? What
Extremely
is the question?
important. Like, how important is it to preserve the sanctity of the court in light of contempt of courts and freedom of speech?
Yeah. So I think I made myself very clear that the courts are Indian temples of justice. We approach them for to grant us certain things which we cannot get on our own. Okay. So at the end of the day, that needs to be preserved. But I think in the end, the judges are human. If they believe that the dignity of the judiciary is being lowered by a particular statement, we should leave it in their hands and they should decide whether that freedom of speech was used in excess and whether it amounts to contempt of court. This is my opinion. What do you all think about the sanctity and?
So I feel like the law in place, it has to be well defined.
Yeah.
So that it becomes more objective. I think apart from that, the law must exist.
Yeah.
But also one more thing which I wanted to add, and we forgot during discussion of Prashant Bhushan's case, was whether a comment has to be first construed whether it's against a judge as a person or the judge in capacity of him being a judge of a court.
Yeah.
I think this is also very clear in the judgment of Bharata Kanta Mishra, if I'm not mistaken, where they said that it is very essential when you deal with criminal contempt to first establish whether the vilification is against a
Yeah.
judge as a person or against the entire judiciary. So in
Correct.
the second tweet of Mr. Bhushan, where he first suggested, I think we can actually break it down into two parts. So here, I think the first part where he's riding a bike, I don't think that can be construed as contempt of court ever, because that's his personal opinion. He's trying and about him personally. But the second part is whether this act is actually affecting someone's fundamental rights and whether this because of this act the Supreme Court is not taking up matters, which is also not true. But the question is, just because it is not true, is it contempt?
For me, I don't think there is any doubt about the sanctity of the courts and the fact that the courts are a temple of justice. But I'm going to restrict my answer to only scandalizing the court, that portion of criminal contempt. I don't think that there is any manner in which you can affect the sanctity of the courts or lower its authority by making statements such as this. And I think the court needs to adopt a more liberal approach wherein it opens itself out to these comments.
Fair enough. I think you have the most liberal and like the pro public view. It's like a
Yeah, it's so
I
clear that
it's
there are three positions, no? One, two,
yeah
three.
yeah
Yeah,
yeah
and there can be several. That's why, in fact, we
Yeah.
encourage that whoever's watching this, please put on the comments what your views are because we'll be very
yeah.
interested to know what your views are. And in fact, if the views are so diverse, we can do another
You,
episode of this or
And tell
probably go
us,
live on
you know the
Instagram.
and
problem
tell
is
us
the
who you
prob-
agree with. Tell us who you agree with. Me, Bhumesh, or Akshay.
no, but jokes apart, one thing is that we haven't covered the full topic only still. Like there's so much remaining right now. So we can
Yeah,
totally have another episode of this.
We
I
can
don't
do
know how.
part two.
Yeah, really, man. Like there's so much more remaining, and we haven't discussed so many aspects of this law.
yeah, true. And
Yeah.
that'll take days. I mean, Supreme Court has written a 108-page judgment only on this, and that is one judgment. There are several
Out of which
others which
80 pages are about previous judgments.
correct, but those
Yeah.
previous judgments are also more than 100 pages. So,
Yeah,
I mean, if we have to discuss it, we can discuss it for days. So, I think we should conclude this episode. I think we've
yeah,
substantially quite described the entire law in a gist
yeah,
and
yeah.
discussed the judgment, which is relevant right now as well. So, I think it's a good time to conclude, and we welcome all opinions,
Yeah.
suggestions, additions, everything to our discussions today. So, yeah, I would
You
like
won't be held in contempt for speaking out against this.
yeah,
Yeah.
don't worry. YouTube is a free and open platform.
As Lord Denning once said, let me say at once that we will never use this jurisdiction as a means to uphold our own dignity. They must rest on surer foundations. Nor will we use it to suppress those who speak against us. We do not fear criticism, nor do we resent it, for there is something far more important at stake. It is no less than the freedom of speech itself. It is the right of every man, in parliament or out of it, in the press or over broadcast, to make fair comment, even outspoken comment on matters of public interest. We must rely on our conduct itself to be its own vindication. Silence is not an option when things are ill done. When in doubt, read Lord Denning.
That's what I was going to say because we
Yeah.
have to end with Lord Denning.
I think this is an excellent note to end our today's episode.
I think it's been quite an episode and I really enjoyed this one. In fact, way more. I'm glad we had Karma. So thank you, Karma, for joining us.
Yeah.
For those of you who don't know, he's an advocate practicing, a counsel practicing in Bombay High Court in the chambers of a senior advocate, Mr. Abad Ponda. And he was, not Mr. Ponda, but Karma was gracious enough to join us today. And thank you so much. I think your insight, especially on international scenario, history of contempt, was brilliant. Yes, so thank you guys for joining us. And I, I'm just so glad that we've got such great responses. Not only good, but we got great responses for our first episode. and it's been going great. Apart from that, we are planning to do something interesting regarding electricity laws for our third episode. It's regarding the current the high increase in the electricity bills of everyone's electricity bill, especially in Mumbai, and everyone's been complaining. So anyone who has queries regarding this, or if their bills have increased drastically in the past few months, please DM, comment with your questions. We'll be answering hopefully all of your questions in the next episode. And we'll be having another special guest who will be dealing with electricity laws, and we'll be answering all your queries regarding electricity laws and increase in the electricity bills. So be sure you'll drop or DM us with your questions. Thank you.
You
Like,
guys
share,
talk a
subscribe.
lot. See you.
Yeah, we
Bye,
do talk
guys.
a lot.
See you.
Like,
Bye.
share, subscribe. Thank you. Thank you, Karma. See you all.
See you.